Hi, everyone. I'm John Hance, president and founder of Hance Financial. Thank you for joining us today. At Hance Financial, we host webinars on topics that help our clients make informed financial decisions. From retirement planning and tax strategies to cybersecurity and estate planning, our goal is simple. When you're better informed, you're better equipped to make confident decisions about your future. Today's topic is one that touches nearly every family. Estate planning is about more than legal documents. It's about making sure your wishes are carried out, your loved ones are cared for, and unnecessary complications are avoided. Whether you're creating an estate plan for the first time or reviewing an existing one, understanding the basics can help you make better decisions and gain greater peace of mind. For those of you who may not know much about me, I'm a lifelong Minnesota resident, a graduate of Totino Grace High School and the University of Minnesota. Go Gophers. I'm also a certified financial planner professional. At Hance Financial, financial planning is the foundation of everything we do. We help families align their finances with their goals so they can move confidently with clarity. I also want to briefly acknowledge several members of my team that support our clients. My C. Yang Safir oversees client service and operations, and Evan K., my relationship manager, works closely with our clients throughout the planning process. Together, my team is committed to clear communication and exceptional service. With that background, I'd like to introduce today's guest speaker. I'm pleased to welcome Steve Hance. Steve has over 30 years of legal experience and has worked in a variety of practice areas in the legal field, including business and estate planning. Steve, thank you for being here today. To get us started, I just kind of wanted to jump right into why estate plans fail even when documents exist. It seems like today with modern families that over 15 years, a lot can change with a modern family, and families might have documents, but maybe their plan should be changed. Maybe they don't have a plan that's appropriate for them right now. They might have a will, a trust, or beneficiary forms, yet they still experience delays, confusion, and disagreements, maybe even unexpected taxes and court involvements. So my question to you would be, how often should estate documents be reviewed?
Yeah, thanks for having me, John. Like everything, it depends on your circumstances, but on your average, simple, relatively straightforward estate planning scenario, absent material changes, you should probably take a look at it every 5 years, I would say. People forget what they put down on paper a few years ago, and what I find is that span of time, people that were designated as beneficiaries or people that you thought might be good options for serving as personal representative or trustee, they move on or they pass away or your relationship ends with those people. So those are some considerations that usually, I think, at a minimum of every 5 years, to at least take a look and see whether everything is still valid with your lawyer is a good idea. People that have high net worth scenarios with more complicated estate plans that are attempting to diminish or eliminate state or federal estate taxes would probably be well advised to revisit their estate plans more often than that, as usually there's a need to make transfers and make IRS filings that address those transfers. So that's
Sure.
my thinking.
You got to be really active on it. Really, what life events should trigger updates? Any life events that would cause somebody to want to update their estate planning?
Yeah, absolutely. Obviously, if you move to another state or buy property in another state, that's going to be something that's significant. If somebody close to you passes away that was in your estate plan as a beneficiary or as a fiduciary, you'd want to consider changing things. Definitely, if you have a significant change in your wealth, like such as having inherited a significant sum of money, that is a situation where you'd want to take another look at whether things are set up appropriately for sure. And I would
Yeah,
also consider doing it upon your retirement as well. Those significant life changes like that. Obviously, a divorce, yeah, those are significant life changes that you should
mhm.
probably get some looked at.
Agreed. Agreed. I want to move into another topic. challenges that are unique to modern families, and kind of why I wanted to do this segment or this whole presentation was to talk about that, because families are so different today than they were in the past. It seems like estate planning used to be simpler, but modern families today include children from prior marriages, long-term unmarried partners, stepchildren, adult children living in different states, family businesses, aging parents who need support. So these things really require thoughtful planning. And I guess one of the questions that comes to my mind with a blended family is, how do you provide for a current spouse while protecting children from a prior marriage?
Yeah, there are some laws that come into play here. So you have to, like in a state like Minnesota, you need to provide at a minimum level for a spouse, depending on how long you're married or whether there's a prenuptial agreement. But all of those considerations aside, on second or third marriages, a lot of times we can provide for a surviving spouse without eliminating the needs of children using trusts.
Okay.
Trust, we call it a testamentary trust if there's a
Mm-hmm.
trust that arises out of your will, or we
Mm-hmm.
can create another kind of trust called a revocable trust, or even if we want to get real complicated, irrevocable trusts. But the trusts are essentially documents that live on after your death and say, hey, I want the trustee, whoever this person is I named, to manage assets and provide for my spouse after I'm dead, but not give everything to my spouse, give the income and a defined access to principal for specific life needs that qualify under the IRS. And that is treated as a gift to the children with lifetime benefits for the surviving spouse. So that's the most common way to provide for a surviving spouse in general out of assets. But then there's other ways too. Sometimes people have assets that are very divisible, like they own
Mm-hmm.
real estate and they own financial accounts and they own intangible assets. And they might decide, we got these three financial accounts and I want these two to go to my spouse if I die before my spouse. And then I want the rest, the balance of my assets, to go to my children, or a gift to my spouse's children and the remainder to my children. So it really is important to know all the players, all the actors, spouse, children, stepchildren, and make clear decisions on how we would like to provide for them,
Yeah.
because there are a lot of different tools we can use to provide for them upon your death.
That's why the data gathering is so important, right?
Yeah, absolutely, absolutely. And it would be a terrible thing to forget somebody in there. And sometimes blended marriages where I've had people who they have had children from a first marriage, from a second marriage, and then they're in their third marriage and their spouse has have children too. That at that point, it really becomes necessary to list all those people out and decide whether you're giving something or want to give something to them upon your death or not. And then be clear about that in your estate planning documents.
Another topic would be unequal inheritances. And with this modern family story, you have children, perhaps some are more successful than others, maybe some that aren't well employed or providing care to the adult parent or something like that. And maybe they deserve some kind of compensation, things of that sort. And so I'm just kind of wondering, we kind of talked about this a little bit before, how should families think about that? Putting in special provisions, or is it okay to have unequal inheritances? Is that a common idea that all my inheritance has to be equal, or are these ideas that it could be broken up? Maybe talk about that a little bit.
The most common is to share equally, but that's not a rule. And I have had many different families with many different circumstances. I can think of a few things off the top of my head as to why families have decided to provide differently for the children. I've seen families decide that maybe one child has already achieved wealth and doesn't need anything, while another child has struggled to gain wealth and does, as a reason to give more to one than the other. I've seen just the opposite. A family who's decided that a child who wasn't competent to manage money shouldn't get as much than a child who has shown competence in managing money. And that's obviously a choice that needs to be made by people individually. It is not uncommon to see caretakers given some kind of benefit for being a caretaker of an elderly
Mhm,
disabled
mhm,
parent. That's a situation that also is fraught with issues because the other children often are suspicious of that kind of gift if it's made by somebody who's frail and needs care.
sure.
And I would say to all of those circumstances, the thing that results in challenges to wills and trusts is the element of surprise. Really, the children are surprised when you die and they get cut out,
Sure,
and they're
sure.
much more likely to challenge or attempt to challenge the estate. And
Mm,
it is a matter of communicating before you die that can help significantly to help eliminate that surprise. And if you haven't or can't for whatever reason, you can communicate in your estate planning documents that you made that deliberate decision. And you may even decide to elaborate on the reason you made that deliberate decision.
I
So
see. Yeah, yeah, that would be good. I think there's kind of a general tendency, maybe, I don't know if it's the Midwest that has reluctance to talk about their money or talk about their estate. It just seems like that could be the case.
oh, yeah, oh, absolutely. That's very common. And that's why I'm pretty blunt to people that they should communicate things to their beneficiaries, to their children.
Uh-huh.
It's not natural for people. Make it a point to ask my clients if they have had that conversation where it appears that it would be important for that conversation to be had. And I think you're right about the probably a Midwest notion. It may happen elsewhere too, but I see that a lot in my office for sure.
Here's a subject that I think is really important and not really addressed very often, and that's incapacity planning. And I just think it's a conversation many families avoid. Most estate planning conversations focus on death, but in reality, many families first face incapacity, stroke, dementia, Alzheimer's, serious illness, accident. I think that somebody needs to be around to pay the bills. Somebody needs to talk to the doctors. Somebody needs to manage investments. Somebody needs to make discussions. So, how do we go about making sure that this stuff is in place? What kind of documents should people be using to make sure that they have this in place before something happens?
Yeah, really important. And to your point initially, you got to have a plan. We're an aging society, and there's more and more people I'm seeing in my world. Maybe it's because I'm also aging, but suffering incapacity of one form or another. And so there are several different ways to make sure that your needs are provided for in the event of your incapacity and that of the people that you support.
Mhm,
And number
mhm.
one is you can the people like your spouse could be a joint holder of your bank account. If you have money in your bank account that could be used to cover needs, they should be a joint holder. So sometimes I've seen couples have separate bank accounts for whatever reason they decided in their life. That person should have access to funds. And that can apply to other things too, not just bank accounts, brokerage accounts, or whatever, as appropriate. Second of all, we often, especially with the wills, we use a tool called the power of attorney, durable power of
Mhm.
attorney. If you check the box in the power of attorney form, it's still valid after a person's incapacitated. That power of attorney gives the person that's designated as the so-called attorney in fact the ability to transact in the name of the disabled person if they are incapacitated. So that's another good tool. And then finally,
That's a great tool. Everybody should have that in place, really.
yeah. And then there's a third tool that is probably the second most, maybe the third most common. I think putting people as joint holders of accounts so they have access to funds is the easiest, the most common way. But the third way is a lot of people nowadays are doing revocable trusts. And there's
Hmm.
various reasons why I, from time to time, am recommending revocable trusts for people. In a revocable trust, it's an alternative to a will that is a document that people use. They can help avoid probate if done right. And it also is an incapacity planning tool because a revocable trust is It's like forming another entity, and in which you are your own trustee of a trust that holds all your assets. And the document says that if you're incapacitated, and it has a way to determine that, then the person that's second in line as trustee would take over, or the co-trustee, if you're a married person, would
Sure.
take over. And so if you have your assets held in a trust, for example, and you and your spouse are co-trustees, and you become incapacitated, your spouse is still a trustee and would therefore still have control over all of those assets held by the trust. So
Sure.
trust's an important incapacity planning tool as well.
Yeah, it is. I would agree. The biggest thing I see is for the financial advisor and the attorney to be working together to make sure that all the accounts get properly transitioned into the trust. A lot of times I see a trust even at somebody's death and there's no assets in it. And they got the trust, but it's just sitting there. That
Yeah,
just doesn't seem like a very
that is a
good.
common mistake for trusts. Unlike a will, which everything goes into your estate when you pass, and is in a trust, it really only works as to, it's only valid as to assets that the trust owns. So it's important to transfer assets into the trust and talk to your financial advisor, because those financial assets, they have beneficiary designations. And
Yeah,
if you have a beneficiary designation on your financial asset, it doesn't matter what you say in your trust,
right.
unless the beneficiary designation is to your trust. That can work for ordinary brokerage accounts, but I think financial advisors are all well aware of this. When you talk about qualified retirement accounts, generally we don't put those assets, we don't designate the trust as beneficiary of those assets, ideally, because
Right.
that triggers the taxes due, the deferred taxes
Yeah.
that
The
come.
5 year payout, but it's still a lifetime for a spouse.
Right. Yep. You, a financial advisor, speaks up about how that works. And in my experiences, financial advisors like yourself are very knowledgeable about that sort of thing.
Yeah. Yeah. We talked a little bit about communication. And so in this section, I just wanted to talk a little bit about family harmony and communication. And you said it before, the biggest estate planning problems are often communication problems. And I think we've both seen families disagree over money. And really, we've also seen families disagree because they didn't really know what mom and dad really wanted. And it's the lack of clarity that creates the stress. And sometimes I think it's so important for parents to discuss with their kids what their role is going to be, or maybe even have a meeting about that, their thrust to that role. So I'm talking about executor, trustee, where they're located, generals and intentions. How would you recommend go about doing this?
Yeah, back on the planning concept, nowadays, one example that comes up almost every time is, nowadays everybody, myself included, has a whole list of passwords for various accounts that they're subscribed to, or that they're making automatic payments to, and or even your laptop computer, which has maybe a lot of information that might be helpful and needed. And we can't really adequately provide for that in the will or the trust context. You just need to talk to the people that are likely to survive you, to let them know where to find things,
Sure.
and organize it a little bit. As far as the executor goes, we call that a person representative in Minnesota, the trustee, if you got a trust of any sort. It's really critical that you talk to those people about that role. Make sure they're willing to do it, that they think they're competent to do it. And if you're going to have somebody as the personal representative of your estate, then you should make sure either you give them a copy of the will, or you let them know where you keep it.
Yes. Yes.
I kind of like letting them know where you keep it, at least, because you can change that will, and it could be a point of contention if somebody has an old version of the will but in
Yes.
general, I think they need to know where these things are, where to find them. Do you have a safe deposit box? It's not very common anymore, but yeah, I don't know how many estates people have gone through, found a key to a safe deposit box. It surprised them. I think we can deal with some things through our written instruments, but as far as making sure that the people around you have some notion as to what might happen in the event of your death, about but where to find things and what their role is going to be is pretty important. And that's a communication issue.
And maybe the estate planning process could include a letter of intent or some kind of written instructions or something like that so that everybody knows what's going on.
Yeah, sometimes that's helpful for people to include with their will or provide
Mm.
to people. I've seen those included with the will. The person who passed away had left a little note with in the place where
It
they
might
said
even be
things,
nice to do a
will,
video.
or a video. You can nowadays, modern technology.
That's what I kind of like about the financial planning software that we use. The Vault allows you to upload a video like that along with your estate planning documents. So there's everything so easy to get for the beneficiary to understand what's going on.
Yeah,
And
that makes a lot of sense to me, that having the vault available to somebody, because things end up in boxes and you
mm,
don't find them.
yeah. And yeah, it just is a very good way to have everything organized. And then if something happens, we're there to help them unravel and take charge of helping them get the assets transferred over. And we have all the documents right there to do that with them. So it really brings a lot of clarity in the estate planning process after somebody passes away. Another one that I wanted to chat with you about was digital assets and modern risks. And we kind of talked about that a little bit. And it's because we're so online now, our online banking, our investment accounts, our cryptocurrency, social media, password management. You see people that have passed away and their stuff is still online. It hasn't been taken down, and who knows if it ever will be, right? And so, how can you plan for this? What are some best practices for somebody to make sure that their digital life gets erased after they're gone?
Yeah, this is an area where I think the legal tools are still catching up with the practical reality on the ground. We do have a provision that we include in wills and trusts that expressly provides that the trustee or personal representative, as the case is, shall have authority to access any electronic sites that involve the deceased as they're in their role as trustee or personal
Okay.
representative. But making 1-800 calls to national or international tech companies is usually not very effective.
Impossible.
Yeah.
Impossible. Yeah.
So
Yeah.
I think that provision should be coupled with organization and communication on the part of the the planner. So you want your kids or your heirs to have your password list after you pass. And it may not get them everywhere, but if you're keeping a good list and you've got it saved in a place that can be found, that gives them a much greater advantage than just letting everything fade away or
Yeah.
not upon your
Well,
death.
what's so hard right now is we've got this generation because digital and technology came on so quick. You have this older generation that is just not capable of keeping up with it and having a password manager and storing all this stuff and knowing how to do this. And then you have the younger generation that's very good at it right now. And so it's going to take years until people are comfortable enough to work with their digital information, I think. What is the digital asset provisions? Maybe you could address that.
Yeah, so the digital asset provisions are those as a reference. They're kind of detailed provisions that we plug into wills and trusts that are intended to be useful to those personal representatives and or trustees, that if they have any pushback from a up company that has digital assets of the deceased, this can be presented and it says with abundant clarity that this person has the role and the ability to act in the stead of the deceased person,
Yeah.
um, so with regards to their digital
It's
assets,
like a power of attorney, basically.
something like that.
Yeah. Very important to get that done. Moving on to another topic would be special needs children. How can support continue without affecting benefits? How can parents give money to their special needs kids without affecting benefits?
Yeah, there are the special needs children typically qualify for state and or federal benefits to help them with their lives, and usually people would like to preserve the ability to draw those special benefits from the government, and but they also want to provide as much as they can to their children. There are ways to provide for children in a specially worded trust, so-called special needs trust, that give the kids access to money in a defined, measured way, doesn't disqualify them from public benefits.
Sure,
So
sure.
for special needs children, typically what is created is a special needs trust. If you want to create up a fund for that child's lifetime that doesn't otherwise disqualify them from government assistance that they're entitled to.
Would that generally be for somebody with a bigger estate that would be putting together a special needs trust just because of the complexity and expense?
Yeah, it's an irrevocable type trust, and as the word implies, you can't take it back. And when you have an irrevocable trust, that is a new entity that needs to have a taxpayer ID number and file returns,
Mm,
and so yeah, that is requires a commitment of resources, not just on a one-time create the document form, but also on an annual basis. And yes, since those people are often receiving public benefits, the people that are typically creating those trusts are doing it with excess financial assets and are typically more established financially.
Regarding a family business, if somebody dies, who takes over? Is there a succession plan?
Yeah, that's so as I indicated, I have done business law throughout my career, and family businesses are a complicating factor in the States. And because oftentimes, especially in a multiple child scenario, there's one or more children that are involved in the business and one or more children that are not involved in the business. And so it's important to give some careful thought over how you want to provide for those people upon your death. And there's different ways to do it that can be discussed and customized. One thing that people sometimes do is they provide for all of their children as owners or beneficiaries, and but only one or a select couple of children are actually able to make management decisions in the business because of their familiarity with the business. It's one way to
Sure.
do it. Another way to do it is providing the business assets to the children that are involved are going to continue to be involved in that business, child or children, and then providing other assets to the child or children who are not going to be involved in the business. They don't those children don't have to be dragged along as minority owners in a business they have no control over. And I've seen lots of conflict there if you just pass on the shares to your children and let them figure it out. Lots of lawsuits happen over that.
Bottom line requires a lot of additional planning if you have a family business, correct?
Absolutely. If you have a family business and you anticipate that family business is going to survive you, then you should think very carefully about how you're going to pass that asset on to the next generation. And I think that's one of the most important things that people need to address if they have family businesses. Just letting it fall in the laps of your children and having them fight it out is never a good idea. The next generation of ownership of that business, that is going to be more complicated than the first generation if you started it yourself, because you came in for your passion about that thing that you started the business about, and the kids are coming in as a second generation without the same originating mindset. And there's always one or two that just completely want out, and there's always one or two, or typically one or two, that want control.
Mhm.
And so how do you balance those competing factors? And that requires planning. You can plan for
Mhm.
that in your estate planning documents like your will or your trust, or you can alternatively plan for that in the business entity itself by the ownership
Mhm.
of shares and how you structure those share ownerships or membership units owned.
Another subject would be charitable intentions. If somebody's charitably inclined, how should charitable wishes be documented?
Yeah, charity is a really great tool, especially for wealthy families, because it's not subject to estate tax. So your power of giving is greater. If you have an estate taxable estate, you can give more if you're giving it for a charitable purpose. The high net worth people, they sometimes they could create their own charitable organization or give to charitable charity, and that can take their estates from taxable to untaxable in just by giving charity. And but every will or trust that we draft has, we can easily incorporate gifts, specific gifts to charity. And in that case, it's important to clearly identify the charity that would be the recipient of the gift. I just recently dealt with a situation where the language used in the will was a little ambiguous, and the person representative thought they had found the appropriate charity, but they sent a check off. It came back to sender. That charity wasn't the same as it had been before. It was a different location, had a different name. So it's important to clearly identify the charity that you want to give to. But there's a lot of different ways to give to charity. In a simple will, you can give a small amount or a medium amount or a large amount, whatever you wish, to a charity that you designate specifically. And for high net worth clients, you could do everything from gifting a significant amount of your estate to a charity, to setting up your own charitable organization and gifting it to that as an irrevocable trust scenario.
Great subjects. Great subjects. Okay, one thing I wanted to just talk about is an estate planning readiness checklist. And for people that are listening, you can score yourself, yes or no. And this would give you an idea if you should be having a review meeting regarding your estate plan. And one of those would be is that your estate documents reviewed in the last 5 years. Beneficiary designations have been reviewed. Healthcare directives completed. Durable power of attorney completed. Digital asset inventory exists. Family knows where documents are located. Executor is willing and able to serve. Trustee is willing and able to serve. Plan reflects current family structure, family would know what to do tomorrow. That's a great thing. Will your family know what to do if something happens to you? I think that's a great checklist that somebody could
Yeah.
walk through and to see if they're ready to go. But geez, I really appreciate all your great insight into the estate planning, and Steve's contact information is on this webinar, so you can certainly get in touch with them, and we'll be happy to get it to you if you need that. But just to wrap up is that estate planning isn't really just about documents. It's about clarity. It's about helping the people you love avoid unnecessary confusion during difficult moments. The goal isn't perfection. The goal is knowing your wishes are understood, your family is looked after, and you've taken thoughtful steps to prepare. Retire with confidence, because when important decisions are addressed ahead of time, you can focus on making memories rather than worrying about what might happen next. Reach out if we can help you with your estate planning.